Perfect. All right. So like I said, we have over 100 people signed up for this webinar. So if you guys wouldn't mind putting who you are. Thank you, Esther. Yay. We love seeing you here. Yes, Angie. Let's do this. Get everyone going. Perfect. Yep. Thank you, Nicole, for putting your title, VP from Pleasanton. Nice job. Perfect. And then we've got our fabulous speaker, Alison is here. We'll get us rolling. Great information. Already looked at we ran through the presentation. I'm excited for you guys to hear it. So glad you guys all signed up. Perfect. Oh, Alice, way to be here from Colorado. Love it. Yay, Bonnie in the house. Good to see your face, Bonnie. Perfect. And you guys I'm so excited for Alison because you guys are true expert in the field. She actually has her teaching credential and is a lawyer, so she has it all. So she truly knows, right? You know the difference when someone's actually been in the field. So it's so fun to be able to see all this. All right. Oh, another celebrity, Brenda O'Shea in the house. I see you, girl. Love it. Perfect. Like I said, we had over 100 people sign up for this. I just want to make sure we get everybody on before we get officially started. If you guys have, even after you guys introduce yourself of where you're at, if you guys have like, what are why are you here? If there's some kind of burning question you want to make sure we have, you guys can always drop it in the question. And then I know Alison will be answering those questions at the end, but if you want to put in there now, it's up to you guys. If you're like, this is what I want to know, we want to make sure you get what you need. If you do it now, or if you want to wait until you hear her presentation. She's going to truly walk you through the entire case from the Supreme Court and just what schools can do and how this affects private and public schools. So this is a very important thing with the whole policy piece. So yay. All right, Heidi from Massachusetts. See, we got every state getting rolling here. Love seeing all the different states. And Alice from Colorado, yay. We've got our students in here too, which is awesome to always see. People wanting to learn. All right. Yes, Kevin from North Carolina. Good to see you, friend. All right, yay, Aaron. We got Aaron from FOSI in the house. Love it. Keep introducing yourself. We're just, like I said, we had over 100 people sign up, so we're just giving some time for people to jump on before we do the official introduction and get us started. Everything I'm recording today and the PowerPoint will be shared with you at the end. So that's exciting stuff. So for your note taking, just know whatever Alison shares in her PowerPoint, that's going to be sent to you as a follow-up email. So for what you're note taking, that you guys know that as well. So recording and the PowerPoint will be shared with you at the end of the presentation. So be ready for it. Perfect. We got DC in the house. All right. Like I said, I'm super excited about Alison being here because it's so fun that she not only has experience in law, she also experiences being a teacher. So it's definitely the expert in the house is here. All right, we got Florida, love it. Oh, virtual school, Palm Bay, Florida. Yes, Lynn. The nationwide organization is here. All right, I think we are ready. So all right, so just if you guys don't know who I am, I want to make sure I introduce myself. My name is Kim Carr. I am the executive director of and co-founder of #ICANHELP. I am so excited about this webinar. It has been such a hot topic. I've been following this court case since it started, just because I knew it was going to be affecting a lot of schools, and I knew I needed to figure out how the organization can support schools, students, especially admin. So like I said, everything that's going to be recorded today, the PowerPoint, everything is going to be pushed out to you afterwards. So for your note taking, if you're sitting there like wanting to make sure you get it, Allison has been so nice and generous that she's like, nope, everything is going to be shared afterwards to you, so you guys do not have to worry on that. But with that being said, I want to make sure I truly introduce Alison Saros, who you guys, I'm so honored that we just keep getting connected with the right people on their different pieces. Not only has she been in criminal defense for 25 years, she's a criminal defense lawyer, right? She's a deputy district attorney in the LA County, and that she's been doing that for 16 years. She was a law professor teaching students to be on the criminal side. And then what the coolest part about her, I really feel like the why she's so great in education is she has her teaching credential. So she has experience in being an educator, being an admin, and being a counselor. So I just think that's just such a cool piece that she got into it, and I'm sure she'll go into that more in details. So just being able to speak with her and have these different conversations, she truly is the expert, is here to truly help as many schools, students, admin as possible to be able to get this information out there. So with that being said, if you guys can put your hands together with the little emojis, so we can give it up for Alison Saros.
Hi, everyone. How are you? It's wonderful to be here, and I have connected up with ICANHELP, which is this amazing organization that's really there to promote social justice awareness and safety online, and really helping all of us grow as social media and the internet and technology changes. As Kim mentioned, I do have this bizarre crossover background. I would say, my education career is more of my midlife crisis, where I went back to school, and I am now come to you with both a criminal background as well as an education background. I am trying to find out, let's see. Okay, so to give you a little background and the reason why I'm here and why I think that this is a good fit for Kim and her amazing organization is I was a prosecutor in LA County for over 15 years, doing everything from trials, felonies, murders, rapes, domestic violence, DUIs, you name it. I did a lot of filing of those cases. I did a lot of teaching of police officers, training on constitutional issues, which was always kind of the forefront of why I did my job. And it wasn't to put away the bad guy, it was to find out what really happened, to get to the truth, to find a resolution that was commensurate with the acts that occurred while protecting the victims and society at the same time. I was a law professor for over 7 years at the law school I went to, Southwestern in Los Angeles, California. And I taught criminal constitutional law. I taught a practical skills-based class where I helped law students really understand the justice system, not moot court, which is the standard case, but really, what does it mean to get arrested? What does it mean to transition to the prosecution agency? How does a case get through the process? And so in doing so, I really realized that there were a lot of students out there and a lot of young teenagers out there that really were getting lost in the system. I one time had a student he was a student, but he had been arrested over the summer for stealing a $50 bike from a garage with a bunch of other juveniles. He had just turned 18. He had grown up in Compton. He was raised by this amazing mother who kept him out of gangs, and he had a D1 scholarship going off to college. He had done everything right. And stealing this $50 bike resulted in him getting arrested for a residential burglary, because in California, if the garage is attached to the house, and someone steals from an attached garage, it is a residential burglary. And so his entire life disappeared. And I said, how can I work to figure out a way to help in the school system where the parents don't necessarily have the ability to affect the change that educators do? So I went back to school. I actually turned to the dean of my law school and I said, will you write me a recommendation so that I can go get my master's in teaching? And he said, you're a professor, why do you want to teach? And I said, because I really want to help those that can be helped by the knowledge that I've gained over the years. And so I started actually with substitute credentials with California Education, CTE credentials in California. And all through my program, I actually worked as a substitute teacher. And so while doing so, I actually transitioned and ended up getting my master's as and in school counseling through the Department of Education, or through the ed department at Loyola Marymount. And so I came out with PPS credentials. So I'm a licensed school counselor. I'm also a licensed substitute teacher at the moment. And so then I worked in the schools as a licensed counselor, working with admin, working with the students, really kind of understanding the mental health issues, the curriculum issues that were faced in the schools, dealing with social media, dealing with discipline. And so I went out in private practice a few years ago and I combined the two. So I bring to you kind of my academic love of the Constitution with really understanding what it's like to be on the school side and also be on the other side, working with families. Normally, every school, all of you I know have your counsel and your lawyers. I'm going to try to share not only kind of the advice that they would give you, but also the advice from the other side. A little bit of frustration that you hear the parents expressing and how we as educators work together to reconcile this in the confines of what the law is. So that's why I'm here. I love working with teenagers and kids. From an education perspective, I spend a lot of time putting families in their place because they're overstepping, overreaching, expecting too much. And so I don't really hold myself out as an education lawyer in that regard, because that's not really what I do. I'm really just working with families and kids and trying to kind of make a difference. So let's talk a little bit about the case that we're here for today. And this is a case, and like Kim said, those of us in this realm have been following this closely. We know the direct impact that it has on schools across the country, even at the upper level in college and at the university level. And I'm going to start a little bit back. We're going to go back a little bit to our 5th grade history class and talk about the First Amendment. We know what it's all about. We know the idea is everyone has a right to be heard, to have their voices heard, to speak. And the First Amendment breaks it down into 5 categories. We know about the speech, and that's what we're dealing with today. We know we've heard a lot about religion and what we can do with that in the schools, what we can't do with that, what we're allowed to do. The press writing something in the school newspaper, elsewhere, the right to assembly and gather, the right to peaceful protest, the right to file a petition and say, all of us are unhappy about this in a peaceful way. These are obviously our freedoms that our First Amendment provides. And over the course of our history, the Supreme Court has sparingly taken up a few cases in order to really kind of give guidance to all of us on what that means. Speech is what we're dealing with here. And speech today is very different than what we used to think of as speech, right? We think of people shouting free speech, holding up posters, holding up billboards, gathering outside places to be heard. Well, the world has changed with social media. And now there's a way to be heard without being known, where you are anonymous, where your face isn't there, where you don't have to take a proactive stance. And it allows people who wouldn't normally speak up to speak up. And in a large way, that's good. But it also allows people to do a lot of very, very mean things and destructive things that impacts others, that impacts our students, that impacts our kids. And it is that which we are going to try to balance with what we know is problematic and what we can do about it. So, you know, those are the spoken words. And spoken words can be in the form of social media posts. We talk about our expressive speech, which in this case we will see is, you know, our hand gestures, our movements, symbolic speech, which we know, you know, our swastika showing up somewhere on a book. Is that okay? Can we as a school punish? Can we discipline? What can we do? How do we do it when all of a sudden we know that there's very, very racist speech being communicated from a student to others? Here's what we do know. And this is a list that I would definitely have you write down and identify. What is not protected speech? It's sometimes easier to go there. And if you can fit it into one of these categories, then we can discipline for it. Obscenity, not vulgarity, in this case specifically delineates between the two, but obscenity, nudes. We see a lot of sexting. We see a lot of nudes getting sent around. Can we punish for that? Absolutely. Defamation and slander, defamation, which are false statements, either spoken or in writing. They're false. That's the most important word here. What can we do? Just because someone says something doesn't mean that it's protected speech if the information is false. With teenagers, we're seeing a lot of social media accounts getting set up falsely and then holding themselves out as if they are another student. I recently handled a case where a student was seen on a video dancing and mouthing the N-word. When we questioned her about it, she adamantly denied that she said those words. We actually had the videotape slowed down and analyzed by a lip reader. She happened to be deaf, out of North Carolina. And she confirmed that those words were not being uttered by the student. And she had been disciplined and she had been punished. And she kept saying, I didn't say those things. The issue is because the creation of that video was false, we can now punish the person who posted it for bullying, for defamation, because what that person did really created a problem for this student. She became suicidal because the video went viral and they thought she was doing something that was inappropriate. So that kind of falls in line with the fraud or the false advertising. If a student is creating something false and holding themselves out as another student or doing something that is not true, we absolutely can address it. Fighting words. Fighting words kind of crosses over into the incitement, which is the next one. Are they saying something, encouraging somebody else to create an uprising? These are our Capitol riots. This is a quintessential example of fighting words and incitement for imminent lawless action. They're going out there in order to rise up other people to create problems. If students are doing that, it is not protected speech. Child pornography falls into the obscenity realm, the same thing. If you're sending around nudes, whether it's of an adult or a child, it's not protected speech. And then they say, which we all know, that speech in special places, prisons, military bases, and of course schools, which is what we're talking about, have a right to control their environment, have a right to make sure that there's not disruption, have a right to make sure that students and teachers have equal access to the curriculum, can say what they need to say, and learn in a safe environment. That is our job as educators. So what we have here is we're going to talk about a little bit about Tinker, because that is our case that got us here. This was a case that came down, and as we know from Tinker, we're going to talk about it in a second, it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. This has been ingrained in us since the late 60s, early 70s, during the Vietnam War. Tinker is our case. It's our United States Supreme Court case. And it was 3 public school students who were protesting the Vietnam War by wearing armbands. The principal said, if you show up at school with those armbands, you're going to be suspended. They disregarded the principal and they showed up and they were suspended. And they took it up and it went all the way up to the Supreme Court. And what was interesting here is that's where our substantial disruption test was created. One of the things that I learned when I went to law school is I didn't really understand how Supreme Court cases had an impact on our lives directly. And it was one of those situations where the more you learn about the cases, and then when you move into education and you're trying to understand well, can I discipline this student? Was there a disruption? Then you understand that this test that was created by the Supreme Court becomes the language that we speak day to day to make these determinations. And that's kind of what the Tinker case was for education. And it's been around for many years, and that's what we've been following. So the issue is the court in Tinker recognized that speech can be limited on school campuses, but students don't shed their right completely. It cannot be disruptive or interfere with the operation of the school. So what do? We look at, did it interfere with administration? Did it interfere with a teacher's ability to teach a class? Did it interfere with another student's ability to learn, to feel safe at school? Can they go to school and not worry that the person who made these bad comments about them are going to cause them harm or stress or anxiety or prevent them from learning? Okay. Years later, we now have a case that has just come down by the Supreme Court on June 23rd of this year. I keep calling it Mahoney, but it's Mahanoy. So I apologize to anyone out there from Philadelphia or Pennsylvania, and I'm mispronouncing this, but Mahanoy is the name of the case. It is the school district. The student, we use her initials BL, although there are a lot of articles out there using her real name. I'm going to refrain from doing so. Here's a situation where we have a public high school student who tries out for cheer. I personally know a little bit about it. My daughter was a cheerleader, former gymnast, and those tryouts are brutal. Very competitive, as they are in a lot of sports. You know, there's many sports out there in high school that are no-cut sports. Cheerleading is not one of them. And students work very hard for years and years to make the team, and there's lots of high expectations. So here's what we have. We have our student who was a freshman. She cheered for JV. She was hoping to make varsity. She went to tryouts because cheer makes you try out every year, at least most schools do. And she got put back on JV. Needless to say, she was pissed. She also tried out for softball and tried out as a right fielder and didn't get her position. She also was angry. So now she's hanging out with a friend at a convenience store called Cocoa Hut on the weekend. And she posts 2 Snapchat posts, pictures, both of them using profane gestures and basically saying that she wasn't happy with the cheer and the softball teams. And she used the F word, and she gave the middle finger. One of the cheerleaders screenshotted the post, and she showed her mom, who happened to be one of the cheerleader coaches for that school. It then got back to the rest of the cheer coaches. It got back to the school, and she got suspended. Suspended for the entire year. She got kicked off the cheer team for the entire year. One of the issues that the school district relied upon was that the issue got discussed in algebra class. However, the algebra class was taught by a cheer coach. So it was disseminated to her private story, which was about 250 students, which is a lot, and that students approached her visibly upset. The hard part is that there really was no analysis by the school district as to whether or not this caused not a disruption, but Tinker requires a substantial disruption. Were kids not able to learn because of it? Was cheer not able to go on because of this? The coaches determined that she violated school rules, she violated team rules, and she went back and she said, I apologize, I shouldn't have done it, it was inappropriate. And the school said, unfortunately, too bad, so sad. From this case, we have Justice Breyer, who is the authoring justice. We cannot lose sight of the fact that in what otherwise might seem a trifling and annoying instance of individual distasteful abuse of privilege, these fundamental societal values are truly implicated. So here's the question. For those of you that work or have teenagers, they use the word annoying all the time, right? You're so annoying, mom. I've heard it for years. Everything is, you're so annoying. Not harmful, but annoying. And so my kind of rule of thumb is, did what this student say, was it annoying or was it harmful? Did it really cause harm to someone, or did it bother them? Did it upset them? So here's what's interesting in this case. The school district really fought this and really disregarded the fact that we were talking about something that if a student said this during nutrition or during lunch and said, F this, F cheer, talking to a bunch of friends, no one would have thought twice. They wouldn't have. But that was the speech that was used. So teenagers starting as young as middle school are walking around dropping F-bombs, using profane language because they think it's cool. Are they doing it to harm? No. Are they using it to get attention? Absolutely. Does it cause a substantial disruption when a bunch of guys are sitting around on the football field or the coaches are throwing out language in any sport that we would choose to not say if it were in writing on social media? Of course. That's how we are. We talk the talk to feel cool, to fit in. That's what students do, to get our point across, to know we're serious. The district court immediately stepped in this case, and this is what's interesting. Often cases that go to the Supreme Court flip-flop. There's a decision at the lower court that's in favor oftentimes of the school because they're very in favor of protecting the integrity of the school, what the school is doing. And then it may go to the appellate court and it may get reversed. And so the Supreme Court says, there's a lot going on here and we don't know how to figure this out. So we're going to take it out under and we're going to review it. But that's not what happened here. The school district got shut down in the district court. This family BL went to the district court and said, I got kicked off cheer because I said something that the cheer coaches didn't like. Not that it was false, but that they didn't like it. If she had gone up there and lied and made a statement that was false on social media, we would not be having this conversation. But she said something that was unpopular to the cheer coaches, that she doesn't like them, that she's mad at them. So the district court found in favor of her and they granted an injunction and they said, school, you screwed up, put her back on the team. And they said, Tinker says, visibly upset doesn't cause a substantial disruption. Algebra teacher who's a cheer coach talking about it doesn't cause a substantial disruption. The school said, we don't like the district court decision. We're going to appeal. So they take it to the Third Circuit. And interestingly, they delineated on a different standard. They say, we're not even going to just touch Tinker right now because Tinker discusses on-campus speech. And this was off-campus speech. And they say, freedom of schools to discipline on-campus speech does not apply to off-campus speech. The rules are not the same. Schools, you can't decide to control everything a student says 24/7. You overstepped. Interestingly, and I'm going to discuss this a little bit for our California educators out there, California actually has a specific legislation in place that has been in place called Leonard Law since 1992 that delineates between on-campus speech and off-campus speech. It's specifically for high school students. And the reason behind the Leonard Law is that high school students, even middle school students, are coming into their own. They're learning to find their voices. They're learning to stand up and affect change. And we as educators, it is our job, it is our obligation, it is our duty to support that unpopular speech. And California's Leonard Law says, not only are public schools tied but private high schools are as well. So for those of you that are there with legislative responsibilities, whether they have them in your states or not, stay on the lookout, because this on-campus versus off-campus speech is what is critical. Okay. The holding in Mahanoy from the Supreme Court ruled 8-1 following Tinker. And they said that her Snapchat post at Cocoa Hut from her personal cell phone on a weekend, getting disciplined for it violates her First Amendment rights. The decision was authored by Justice Breyer, who is a liberal justice. Now, I know we've heard a lot about the Supreme Court justices over the years. I mean, over the last couple of years, especially with our change in administration, especially with our desire to affect political agendas moving forward. The thing that I love about this area of the law, and specifically about this case and this decision, is that with the exception of Clarence Thomas, who in the dissent had his own reasons, this was a decision that was made equally by all the justices. This was not political. It wasn't divided. It said, I don't care what your political background is, what your allegiance is, what president you want in the White House. First Amendment has to apply to all. And in schools, it has to apply to all. And the schools are required to be the backbone of supporting their students' First Amendment rights to voice unpopular opinions. The school district argued three things. And when we look at it in hindsight, we can say, I understand why this really wasn't the case that the school district should have been fighting. I do wish there were a stronger case put forth by the school district so that there was some validity to their arguments. They argued three basic things. They argued it's not good manners. First Amendment speech often is not good manners. Using vulgarity doesn't mean it violates the First Amendment and is not protected. And then the issue is the substantial disruption, which we touched on. And the school district's third argument was team morale. It affected the cheer team's morale. And the issue, once again, turns to, well, did it cause a substantial disruption? Did it stop cheerleaders from showing up? Did it prevent them from talking to their friends, to doing what they need to do as athletes, as cheerleaders? And this court said no. And then it went on to define off-campus speech. And speech that is outside school-owned, operated, supervised channels that is not reasonably interpreted as bearings on the school's imprimatur. So that's the kind of legal buzzword that we're talking about here. And they analyzed it. Does this go to the school's reputation? Does this go to who they are? Does this demonstrate lack of respect for the school or the administrators by the language that she used? But not just lack of respect. Does it compromise the school and their ability to do their job? And the court said it was outside school hours. It was outside of school. She didn't identify the school or a student. It was on her personal cell phone, not a school computer, not a school iPad, not on a school Facebook page or a school website. The audience were her private circle. She did not post it on her public Snapchat or her public Instagram. It was on a private circle to private friends. And the question is, does all of this mean that the school has a diminished interest in disciplining the student? And the case said yes. Okay, so let's talk a little bit about where it is okay to say this is not protected speech. Tinker came out, and then over the last 30 years, there have been a string of cases that kind of address similar issues. And they make decisions on whether or not that particular speech constitutes protected speech or not. So we have Bethel School District versus Fraser. That is a situation where a student got up during an assembly and used very sexual language in their speech, and then argued that it was political speech because it was protected. In 1986, the Supreme Court said, nope. Sexual speech is offending, especially in a student environment when you have younger kids. You can't use words that are going to create issues, cause tension. And they said, that's not protected. Morse versus Frederick came out more recently in 2007. This is the Bong Hits for Jesus case, where someone is walking around with a t-shirt that says Bong Hits for Jesus. The Supreme Court came out and said, not protected speech. We do not promote illegal drug use. And the last one that was interesting was Hazelwood. And this is a case where some students in the school paper published an article on teen pregnancy, on teen divorce, and the principal went in and edited it and removed it before publication without telling anyone on the newspaper. And they objected. And it went up to the Supreme Court, and the Supreme Court said, it is not protected speech. This principal has a right to protect the information that is going out as representative of the school, and the school paper is representative of the school. And if we don't want to be talking about teen pregnancy, it's something that the administration can censor. Okay. So this case was great because what happened is all of these organizations got on board, and a lot of them actually got on board supporting BL. And they went out there and they said, there's a lot of things that schools can discipline for, a lot of things that they need to protect for. These are a few of them that they do, but BLs did not. And so what's interesting in this case is that this is a roadmap for educators. This is telling you that the Supreme Court is saying that if you punish for these things that they identified in the case, you're probably going to be okay. They didn't make a test of it like Tinker's substantial disruption test, but they identified many of them. All times when the school is responsible for the student. Now, that's not 24/7, and we're going to talk about that in a second. But that's during school, during class, extracurriculars, travel to extracurriculars, to and from school, traveling to and from school, the immediate surroundings, the park next to the school, the hangout spot, arguably at the 7-Eleven that's 100 yards from the school. If they're doing things there that may be problematic, I think we have a good argument to say we need to do something about it. Things involving school taking place over a laptop or a tablet, taking place during remote learning, which is what we're all dealing with. Activities that are done for school credit. So if kids are required at your school to do community service and they're acting out at community service, can we do something about it? Yes. Communication to school emails or phone, or I'm going to expand that and say Facebook pages, Instagram pages, websites that are being used to communicate between administration, students, and teachers. Anything where this is going on, those things can be addressed, not just for students, also for teachers. Okay, now, those are kind of examples of speech when we can address it. Let's talk a little bit about the things that we know we can address that legislation all over our country is working specifically on. Serious or severe bullying. And I invite you to pay attention to the terms serious, or severe. In talking to parents, I have parents walk in my office on a daily basis and they say, my kid was bullied. Really? How old is your kid? She's in kindergarten. What happened? She was picking on another student and she got benched during recess. Who's bullying her? The teacher. She's not letting her play with the other kids during recess, and the other kids are looking at her and laughing. The teacher is bullying her. We all know from an education perspective that that's not bullying. So the issue is we need to heed guidance from our legislation and our directions on what bullying is. In California, we have it defined. We have Seth's law that went into place many years ago, which is an individual who ended up committing suicide because he was severely bullied. We have uniform complaints that the school districts are now required to tell parents about when there is bullying so that they can take action. But we know, because we hear it over and over again, everything that a kid does that's mean isn't bullying, and certainly isn't severe or serious bullying. But if it rises to that, if there's false statements made, and that's what you want to look for, is someone is posting something for someone else, representing someone else, it is false, it is defamation, it is not protected. Especially with the social media realm. Harassment targeting particular individuals. It's the same thing. You want to make sure that you hang your hat when you're writing up your discipline on as many things that apply. So for instance, when I used to train police officers on conducting a traffic stop, there were lots of bases for conducting a traffic stop. And I would say, make sure you have more than one. So for instance, we have a statute in California that I call the fuzzy dice statute. If there's something hanging from the rearview mirror that's obstructing the view of the driver, police officers can pull you over. If you don't have a front license plate, or your registration is expired, or your windows are tinted, you can get pulled over. But I always suggest to the police, don't just hang your hat on one. Make sure you put in many. So if you're dealing with a situation where you have social media harassment online, bullying online, and you need to determine whether it's serious or severe, don't forget the fact that it likely is false. And that is your strongest argument, because that is not protected speech. So when you're writing up your reports, make sure you identify all of them, list all of them. List that it is severe, list that it is bullying, identify what makes it severe, identify that it is harassment as well, and identify that it is specifically targeting another student, a teacher, a group of students, the campus. If you have threats, which I know we see all too often these days, who's it targeting? Make sure it doesn't say so-and-so posted something holding a gun. It needs to, there's a lot of students out there, there's a lot of kids out there that want to stand up and advocate for their Second Amendment rights, right? That's what's going on. It's very important that they need to advocate for that. But the question is, who are they threatening? Who's been offended? Breach of school security devices, something in writing, something that identifies. Okay, these are the big takeaways from the case, and I know I'm pressed for time, so I'm gonna run through these. The case lays out three kind of justifications, kind of like Tinker's substantial disruption test. And this is the test that you're going to be asking yourselves, and your administrators are going to be determining. Schools will rarely stand in loco parentis. This means when someone is doing something off campus, is the school acting as a parent, or are they acting in their capacity because they have the right to do so in the schools? And this court turns to schools and says, you need to be skeptical of a school's efforts to regulate off-campus speech. For doing so means you're shutting down the student's voice altogether. And then the big one that Justice Breyer hammers home are the nurseries of democracy. And I'm going to go through all those really quickly, but these are slides to definitely look at again. They talked a lot about the fact that when they're off campus, it should have been BL's parents who decided whether or not what she did on her Snapchat off campus, even though it was directed to the cheer team or just saying she didn't like the cheer team, was their job, not the school's job. So don't feel like you have to take on all these cases. Refer them to the SRO, refer them to the self-help center to get a restraining order through the courts. But it doesn't mean you as schools have to take this on. That's what this case says. Your job is to handle those things that cause a substantial disruption on campus and those that are not protected speech off campus. For schools to justify prohibition of a particular expression, it must show that it caused by something more than a desire for discomfort and unpleasantness for an unpopular viewpoint. And this is what the Nurses of Democracy hammers home in this case. The school itself has an interest in protecting the students' unpopular decisions. We are so busy because people are screaming bullying from the rooftops. They're screaming it. They're demanding that you expel the student, that you kick them out. It doesn't matter whether they're special ed and federal rules apply and don't allow that. They're getting mad at you, and we want to appease the parents to make it easy. I disapprove of what you say, but I will defend to the death your right to say it. I can't stress enough. We need to be able to fight for students with unpopular opinions, even if they are directed at us. This is what I kind of touched on in California. This is 48950 for those California educators out there. It basically says if it's off-campus speech and you're a high school, stay away. And tell the parents you don't have authority unless it's harassment, unless it's severe bullying, but you're going to have to define that, or if it's unprotected false statements or unprotected speech. Okay, high school coaches are subject to the same constitutional constraints of the First Amendment. Can a high school coach restrict or regulate students' athletes' use of social media? Does it happen in every sport? As my daughter's cheer coach, who's one of my most favorite people in the world, says to his girls, you can post about food and you can post about your grandmother and you can wish people happy birthday, but you can't get out there disparaging people on social media. But if you do, coaches, and you can have those rules, how do we handle it? We can't turn around and kick them off the team. We can't turn around and discipline them. But let's look at means of correction. Can we make them exercise? Can we make them run? Can we make the team run? Can we make other students on the team the forefront of the ICANHELP program, empowering students to help other students learn socially responsible behavior with respect to social media? If it's not just upsetting the coach or defaming the coach, it's let the students stand up and tell the other students that disrespecting use of social media will interfere with their success on the team, but it doesn't mean we can discipline them and kick them out. So I'm going to turn this over to Kim on a few issues, but I'm going to end with this. This is Justice Breyer's last part of his last paragraph of this decision. And this is what you should be asking yourself. But sometimes it is necessary to protect the superfluous in order to preserve the necessary. This is a case citing Justice Oliver Wendell Holmes from 1927. They determined that BL's vulgar speech was superfluous. It wasn't critical to functioning as a school. And it's so important that we as administrators, that we as educators do what we can to recognize when students are standing up to something that is unpopular and when they are doing something that tries to or does cause deliberate harm to others. What's so amazing about ICANHELP, and the reason why I'm really enjoying getting involved, is because they are putting together, or they have to put together, and I'm going to let Kim explain these a little further, specific programs to help you and guide you with regard to investigations that have to do with preserving the integrity of online content, of social media, of helping schools administrators figure out what to do when you have 500 things on your to-do list for the week, you have 100 for the day, and all of a sudden you now have a threat on social media that you're scrambling to try to handle. Their policies are designed with examples to help you work through what needs to be done in order to take care of these crazy heightened issues that are, rearing their ugly head every day. So thank you for your time. I'm here to answer questions. Of course, my information is available. My email and contact number are available as well. I don't think I put them on the PowerPoint, but I will make sure that Kim disseminates it. Feel free to reach out independently. I'm happy to just discuss it with you or brainstorm a situation to try to figure out what to do. But thank you everyone for joining.
Perfect. And Allison, there is a question in the chat, so I'm going to give you a chance to kind of look that one over. On that, there's two of them. One's from Nicole. She's a vice principal of a middle school, and then one's from Esther. And if you actually want to stop screen sharing in the middle.
Yep.
Yeah, there you go. Perfect. And I'll put the spotlight on me. But I did want to just go over spotlight on everyone. There we go. Perfect.
Okay.
There you go. Yeah, so I'll
Okay,
get to that
so
in a second.
Nicole.
So I'll come back to, I'll come back to you. I'll make sure everyone, if anybody else has any questions, go ahead and put it in the chat so that Allison kind of can get it, look it over. If you guys have any questions, while I just kind of walk you through some of the programmings so that she can get her thoughts together to be able to answer your questions. What's so nice is she's willing to kind of answer that questions afterwards. If you guys have more, then she'll make sure you have that.
Okay, but I need you off of screen.
I did want to tell you guys about our brand new course that she just kind of referenced. Our admin course, there's a ton of information in there. It walks you through how to create that policy plan. It walks you through how to even do investigations. There's samples, templates for you. There's template letters that go home to parents. There's templates of the actual policy that are there for you. So it is.
Did she just freeze? I'm thinking Kim just froze. Can you guys hear me? Or am I frozen?
I can hear you just fine. Kim froze.
Okay, good. So Kim froze. Okay. Okay. Kim, are you back?
Yes.
Okay.
Okay, perfect. So the other course that I want to make sure I do highlight is our digital citizenship video course. And what this one does is it's a video course, you can get all the students on board. They're on the same page of what is expected. What also is nice is that restorative justice piece. So if a kid does get in trouble, middle school or high school level, you can have them watch this. So this is something Alison and I've been talking about, even getting it in the court system, that if they get to that point, that they can actually refer them to this course as well. So this is also a limited time of $95, which would be a code for your entire school. It's very limited because, as you can imagine, that would be code for everybody. So it's a very discounted price just because it is brand new. But we did put in the PowerPoint for you guys to take a look at all the other different pieces. One of our new ones is, I have a couple schools that are starting it, is an actual course about social media literacy course. It comes with PowerPoints, curriculum, everything charted out for a whole semester level of a class. You can do it for a quarter as well. So all that information is on there. If you guys want to set up a time with me to go over anything, we will have that opportunity for you. But I do see questions in the chat. So Alison, I'm going to turn it back over to you to answer those questions.
Okay, I'm going to start with Nicole's. Hi, Nicole. Okay, so I know that there was a lot of confusion because California specifically has something that's for high school students. However, this Supreme Court case, the Tinker Supreme Court case, doesn't delineate between what level of students we're dealing with. The BL student happened to be a high school student, but that doesn't change the fact that everything that we discussed equally applies to middle school students, to elementary school students. All of them, at this age, we have kids in 2nd and 3rd grade with cell phones and they're sending things out. It all applies. So the standards are still there. The First Amendment protections, although they don't necessarily understand them, are still there. However, keep in mind, at the younger levels, what would be considered a substantial disruption would be different based on the age of the students. So if you have a 2nd grade student dropping F-bombs or making vulgar comments or talking about sex, that's going to offend and be problematic and disruptive to the younger students. That's very different than making those statements at the high school level. So for instance, if one elementary school student tells another student to F off, and that's not a word that student would ever use, and that person gets incredibly upset by it, that younger student, well, then the issue is, do we have a substantial disruption? For certainly on campus. Off campus, we have to go through those factors. We have to weigh the factors and say, is this something their parents should be addressing right now? Is this really our job to butt in? Is this stopping the student from accessing the curriculum? And so that's kind of where we're going. Now, the 48950 of the Ed Code in California, the Leonard's Law, which specifically addresses high school students, has also been expanded by case law to colleges and universities. And there's Supreme Court cases that are pending on those cases as well. And also for younger students like middle school students. So it is arguably applicable. Does that help?
Yes, sorry, thank you.
Of course. Okay, Esther. Esther, your question, and I really like it. Thank you for speaking at this webinar. I'm wondering why problems like this exist. How can we make conversations like this more mainstream? I think that ICANHELP is that exact organization that is helping spread the word to do this. And as they promulgate, and I will too, it is using students to help educate other students, to raise awareness, to share experiences of what it was like when they were bullied, to share experiences of what they were like when someone sent them nudes and they were freaked out. It is a conversation that needs to be ongoing and it needs to be continuing. I would love to get it into, the week before classes start, the mentoring programs, the linked crews, all of those situations, creating those safe spaces for people that are not going to judge, that are not going to patrol, but that can help students when they're faced with this determine what to do, because administrators have their hands full, counselors have their hands full, and they're there for that reason. But we also need to kind of help expand it so the students get directly involved. That's kind of my take on how we handle this.
And I'm going
Okay.
to chime in, and I'm going to chime in too, because Esther is actually one of our students. And that's the thing, Esther, that what makes us stand out. Let me just add myself in here. What makes ICANHELP stand out is we team up with students like Esther, who is in New York, right? It's going to be a senior in high school. And that is what she was saying, is we have to get the students on the ones that are making it the cool thing to do, of how you're talking about your campus online, right? How are they addressing it? If someone does say, I hate the cheer coaches, that could be the case, right? There's some people who don't like certain coaches, and those are kind of things. But it's like, if that's not the culture you want to create, what's the system you want them to do? You want them to come talk to the coaches, you want them to come talk to somebody. That's what your students need to get them on board of, what's the proper channels, because they will continue to use their voice online. So it's making sure ICANHELP can come in and help you guide that conversation with students to get those online leaders, showing students how to do it.
And one of the other things that I think cuts both ways, but there's a very fragile way to do this. When I have parents come into my office, they think that what happened to their student was an isolated situation. a student was mean to my student, a teacher was mean to my student, they think that this doesn't happen to other kids. And so we know we hear these complaints all day long. I think one of the things that we need to figure out a way to communicate and constantly communicate is sending out information on what schools are doing, how often they're addressing bullying and harassment, what the UCP complaints are. Parents come in regularly and they've never heard that they can file a complaint for bullying. And I usually don't encourage them to do so, but the schools need to just help share the word so that when this happens to their kid, they're like, oh, okay, this is happening to a lot of kids and the schools are aware of it and they are addressing it. So when you're sending out information and notices, whether you're elementary, middle school, high school, make sure in those notices, when you're introducing all of the things that you're doing and all the, curriculum has changed so much, Common Core has changed so much. And so we're spending a lot of time training teachers on new curriculum, on new changes, on internet, on the new programs that are out there. And we're changing contracts and we're trying to figure out what the best way to disseminate information is. But we also need to make sure that we're not just talking about the fact that we have counselors here to address it. We need to say, this is something that is prevalently going on, and we need you parents to be part of the solution. And they can't be part of the solution if they're not aware that it's going on. And so that's kind of my 2 cents from the backside. The opposite side is I'm always surprised with how much parents don't know about this, the amount of bullying, the severity of it, the frequency with which these complaints are being reported. So throw out some ways of how it's been handled so that they know that you're on it for them. Any other questions that I'm missing? I see internet issues from Joshua. Internet issues, they all apply here. So it's the same kind of thing. Are we on a school website? Are we on a school forum? Are we posting on the internet in a chat room like Reddit? Are we on, Rate My Teachers? What are we on the internet, I guess? So my question to you is, all of those issues come up. And if someone writes a glaring review about you as a teacher, how do you respond? What do you do? Can you discipline? Can you punish? And so it doesn't matter where it is, it's the same approach. Let's look at it. Is this something the school should be taking care of because it's on campus? Is it connected to on campus? Is a forum used by the school itself? If it's something paid for by the board that you have access to, it's a school related thing. If it's Rate My Teachers, it's not. So those are the things that you just have to be able to delineate: on campus, off campus. Parent job, can we say, sorry parents, this is something you need to take care of, and we can help them find resources. Create a list of things that we can send them to, our local courts for self-help for restraining orders, our school resource officers, the other professionals out there that can help when something like this is happening. Anyway, I know I've overtalked. Anything else that you guys want to address or discuss?
Yeah, you crushed it. Great job, Allison. And I think what we'll do, like I said, as a follow-up email to everyone who signed up for this, we're going to send out the video. We'll send out the PowerPoint. We'll send in Allison's email address if you guys do have any other further questions for her, to kind of have that there. And this just is a conversation to get started. Also will be a link if you want to sign up to be able to have a conversation with me to go over anything, because every school is so different. So it just kind of helps you to figure out what's the right programming that fits for you guys to kind of figure that piece out. So that is what we have. If we can, yes, I'm seeing all the great thank yous on great information. So thank you everybody for showing up. I know that's always your summertime, and your time is always valuable. So we want to make sure it was full of great conversation and great information for you. So please, let's make sure you guys have any questions. We're here to support you and help you. So thank you again, Allison, for your great knowledge.
Of course, I'm here to help you guys. I just, there's so many changes in the legal world, and I want to suggest to you as educators, don't be afraid of talking to the lawyers. Like the minute I try to talk to an administrator and they learn I'm a lawyer, they get very apprehensive, and I just, feel free to use me as a sounding board. I'm here to help. I just want you guys to be able to do your job as educators. You are doing this incredibly thankless job every day. If only people knew how much time, energy, and thought and sleepless nights go into working in the school environment. It's what I shout from the rooftops all the time. So just know that you have an ally in your corner who's happy to help.
Awesome. Thank you, everybody. Thank you again. All right. You guys have an awesome, awesome day. Stop recording.